Even if jurisdiction over landlord and tenant matters was exercised by Section 96 courts in 1867, the jurisdiction conferred on the Residential Tenancy Commission is analogous to a type of jurisdiction generally exercisable by courts of summary jurisdiction. So they make a distinction here between the type of jurisdiction and the jurisdiction, I guess. They're basically saying, and they admit this later, they concede that the powers given to the Residential Tenancy Commission are not merely analogous, they are the exact same powers, kind of conceding the point of the original appeal. They do argue, though, that nonetheless they conform to the type of jurisdiction exercised by courts of summary jurisdiction. Basically, I believe arguing for a shared jurisdiction in 1867, and the court rejected this argument. So, we've got a three-step process set out in this reference. I'm going to go through it first before applying it to this case, but step one is the big picture. It's a historical inquiry looking at the power and jurisdiction of the superior court at that time, and then comparing it to the inferior court, or the legislation to create the specialized tribunal. Now, so power at the time is referring to the remedy that they had the power to enact, and jurisdiction refers to the nature of dispute or the remedy. So we're looking at the nature of the dispute and the remedy of a Section 96 court at the Constitution. And in this case, they looked at the history of Ontario. So the next step, if it's found that it doesn't intrude, or I suppose if it doesn't intrude, then it's valid. If it does intrude, we move on to the next step. And this is flipped from John East, where the judicial one was first and the intrusion question was second. So, is there a judicial function? Is the power exercised judicially? And judicial capacity equals that they are faced with a private dispute between parties, and they're called upon to adjudicate through the application of a recognized body of rules in a manner consistent with fairness and impartiality. Versus a more administrative or more policy-driven capacity, in which they are hearing competing views of the collective good for the community as a whole. And the third step is if there is a judicial function, so they are intruding, they do have a judicial function, is the judicial function the sole or central function? Basically, is it a court? Now here we're dealing with landlord-tenant disputes, so Professor McAvoy suggested imagining Judge Judy, where people are coming in and arguing over, unpaid rent or damage deposits or those kind of things. And this is what the board would be hearing. It's worth noting, though, that they do have an educational and administrative function. And this comes from all the different I think it was 3 or 4 different boards that they swallowed up in order to create this unified commission. But despite these other tasks, their primary purpose is to remedy disputes. So if yes to all 3, it's invalid, or it intrudes on Section 96 courts, it's judicial, and the judicial capacity is its sole capacity or central capacity. It's invalid, or it can be pursued to meet a social policy goal. So it's possible that the judicial powers are ancillary, which I believe kind of brings us back to step 3, as was the case in John East and Tomko. Or it's also possible that the imputed judicial powers are necessarily incidental as was the case in Mississauga, which we haven't covered yet. However, our teacher mentions that every statute addresses some policy function. So it's interesting that you can go through this test and then just based on the fact that there's a broader social policy objective of the legislation that's creating this specialized tribunal, you can ignore, I suppose, the Section 96 protection. So in this case, the decision was that the primary role was to adjudicate, and there was overlap with historic Section 96 courts, and they dismissed the appeal. They said the statutory provisions conferring those powers are therefore invalid. So moving on to the next case, Sobeys Store Limited versus Yeomans. This is inspired by the checkerboard, which is different provinces having different standards for what jurisdictions can be transferred to specialized tribunals. So this was the case of dealing with Labor Standards Code, and the facts are that Sobeys fired a manager that had more than 10 years experience, and according to Labor Standards Code, if it was without cause, then it is against the code, and they were ordered to reinstate Yeoman and pay $21,000 in lost wages. However, Sobeys appeals this decision to the appeal division, and the judge there concluded in step 1 of the test that jurisdiction in relation to wrongful dismissal and to make an order of specific performance regarding reinstatement were within the jurisdiction of superior courts in Nova Scotia at Confederation. So now this decision is being appealed to the Supreme Court of Canada. So it's interesting here, Justice Wilson wanted to answer a few questions before she went to the test, and in this process she, I suppose, clarified the test and some of the words in it. So the questions she wanted to answer were, how broadly should the power jurisdiction be characterized for the purposes of historical analysis? And here she's referring to the inferior courts. Do the words broadly conform to superior court jurisdiction mean that such jurisdiction might have been exclusive to those courts at Confederation? And here she's referring to the issue of shared jurisdiction. Then should the court only look at the jurisdiction of courts of the province in which the case arose, or should the inquiry embrace all or most provinces? So question 1, if you support a broad interpretation of the impugned legislation, then I disagree with this. Okay, I'm going to have to double check this, but I think I have it written down wrong. So if you support a broad interpretation of the impugned legislation, then it's more likely to infringe. And so if you're challenging the legislation, then you are going to advocate for a broad interpretation. And so in this case, Wilson rejects employer-employee relations as too broad a category of jurisdiction. She rejects labor standards as too broad a category of jurisdiction, and focuses on the type of dispute, which is unjust dismissal. So, because the purposes of Section 96 courts require strict approach to the characterization at the first stage, it's a threshold test that must still pass Section 2 and 3. Basically, she's saying that at step 1, we need to have a narrow interpretation of the impugned legislation, because it's just a threshold test and it still needs to pass 2 more. Okay, so do the words broadly conform to superior court jurisdiction mean that such jurisdiction must have been exclusive to those courts at Confederation? This is question 2. before we get to the three-part test. Obviously, Section 96 is violated if a provincial court is accorded power that was exclusively given to them. And obviously, Section 96 is not violated if the provincial tribunal is accorded power that was exclusively given to an inferior court. But there are many shared responsibilities. The inferior and superior courts at Confederation were viewed as broadly coextensive. So they often dealt with the same subject matter, but the type of dispute or the type of remedy or the type of where they were resolving these disputes differed. And she cites Attorney General of Quebec versus Grandet in 1983. Here, for an intruding tribunal jurisdiction to be valid, the practical involvement of the inferior court must have been broadly coextensive with the work of the superior courts. So it can intrude, but it has to be broadly coextensive. So the inferior court's involvement was probably limited in some way by geography. Perhaps they only exercised it in the municipality. By money, perhaps they couldn't give out pecuniary damages, or by function. Perhaps they could only hear about late payments as opposed to the general lesser leasee relations category. So to the question of whether or not the powers must have been exclusive, they do not. So they don't have to have been exclusively the power of, I'm a little hazy on this point, exclusively the power of, if they were exclusively the power of the superior court, then there's no, it's invalid. However, if there is broad coexistence between them, then the power can be transferred to the inferior court, is what I believe. So in Grandet, it was regarding lesser and leasee relations. The inferior court jurisdiction was subject to pecuniary limits. It was province-wide, and it included most matters of dispute between landlords and tenants. However, the judge in this case found that there was insufficient jurisdiction, so that it wasn't broadly coextensive enough in order to uphold the provincial legislation. So question 3, before we get to three-part stat, is should the court look only at the jurisdiction of the courts of the province? And they decided no, they were going to look at the 4 original provinces and use England as a tiebreaker. Laforêt dissented in that and thought that Manitoba, BC, and PEI should be considered, and then we look at England. Some foreshadowing here. We're not going to look at that. We're just going to do the test. So moving on to the test, after answering those 3 prefaced questions. Ontario and Quebec, they had a history that supports shared jurisdiction for labor relations between inferior and Section 96 courts. New Brunswick, Nova Scotia, and England did not. So no jurisdiction for unjust dismissal for labor standards according to step 1. We move on to step 2. The directors are administrative, but the tribunal is judicial, so they fail step 2 as well. Step 3, the judicial power ancillary to the tribunal's administrative function. And she doesn't really answer it. She just jumps to whether it's necessarily incidental to the broader policy goal of the legislature. So the goal of collective bargaining, individual employment relations, landlord and tenant law, or otherwise. And she decides that this is an Employee Standards Act. You cannot be dismissed without cause. It's to protect non-unionized workers. There's a complaint mechanisms. The directors go out and investigate the grievances and then bring back the evidence. It's to have community standards vindicated. The There is direct access to the General Court of Appeal, which is kind of like a